I don't care if
You're not going to do what
I don't
you're
care
breaking
if I
the
lose
law.
my job, buddy. Try me, buddy.
We're going to have a problem.
Try me. Try me.
Yeah.
I'll knock you down like I knocked trees down all my life.
So you're not gonna get arrested?
Yes. It's up to the court.
It is rare to see cops face instant karma, but in the courtroom, justice comes with full force, knocking over these corrupt pigs. Today, we'll be going through these cases where these corrupt police officers were served some quick karma in the court. First up, an entire police department finds themselves under scrutiny thanks to a lawsuit. Auditor Sean Paul Reyes filed a lawsuit against the Danbury Police Department after he was kicked out from not one, but two public areas. Starting with this police sergeant who did the unthinkable.
We're in charge here, okay?
Yeah, you're going to tell me to leave, and then
you're going to have to give us an ID. If you don't give us an ID, you're going to have to go. Then you're going to have to go down.
Not going to happen. I'm not breaking any laws.
Yes, you're breaking their law. And
I can see the tyrant in you, Utter.
Oh yeah.
You're a real tyrant.
Yeah.
I can see it in your eyes.
In law enforcement experience. And I'm still here, but I'm a tyrant.
You are.
Because if I was a tyrant, I'd be long gone.
Violated my constitutional rights. I have a constitutional right to film in public. That's what you just don't understand.
There's no laws or rules in anywhere. You can just do whatever you want.
No, that's not true.
So they have a law that says what you're doing was wrong.
They have a policy. They have a policy.
So they would like you to leave, and that's what we did.
No, but the law protects me to do what I do. You understand?
No.
It's a constitutionally protected activity. It's constitutionally protected activity.
Sergeant Utter thinks he can do anything without being held accountable, but what he says next really gets him in trouble.
I want to file a complaint against him, Sergeant.
All right, thanks, Sergeant.
Grab my arm. Sergeant.
I know. You know what? I'm telling you right now. 5 years ago, he would have been on the ground. Absolutely. 10, 15, 20 years ago, that motherfucker would be dead. His teeth would be missing. I don't fucking.
Wow, this sergeant seems pretty relaxed at someone. Such a disgrace to the profession. And just days later, Sean went over to the Danbury City Hall where he met a tyrant in the form of security official Phil Janusa.
You're not going upstairs. You're going to wait down here.
Don't touch me.
You show me some respect.
Listen.
Listen, you wait
Don't touch
down
me.
here.
Hey, don't touch me. I'm just walking in a public building.
You're a
Okay, great. No, by walking.
I don't want you
Please,
to go upstairs. I have to call upstairs
Please,
first. I have to
get
call
out of my
upstairs
way.
first.
I'm asking
not
you to
going to
get out of my way.
Get out of my way.
I'm asking you to get out of my way.
Get outside.
Get out of my way.
Get outside. You're not coming down. Do me a favor. Go to engineering. Go around the corner and get somebody. You're not going upstairs. You have to fill out a form first.
I don't need to fill out a form.
You're going to fill out a form.
No, I'm not.
You're making the forms right now?
No, I'm not.
You can sign out. You're all set.
You're getting involved in the wrong fight here.
All you're about is having people follow you on YouTube and all that nonsense, disrupting people.
I'm not disrupting anybody.
You need to get
Don't
a
talk
job.
to me, and I'll
you
be.
need to get a real job.
Don't
You're disrespecting
Don't
me.
talk
You're
to
not
me,
gonna go.
and
I'll
I
talk
won't.
to you the way I want.
No, you won't.
I'm tired of
no,
your
you
nonsense.
won't.
I will.
No, you won't.
He had no idea his actions would lead to a massive lawsuit against the city, and yet his behavior was about to get even worse.
You're getting involved in the wrong fight here.
All you're about is having people follow you on YouTube and all that nonsense, disrupting people.
I'm not disrupting anybody.
You need to get
Don't
a
talk
job.
to me, and I'll
you
be.
need to get a real job.
Don't.
You're disrespecting
Don't
me.
talk
You're
to
not
me,
gonna go.
and
I'll
I
talk
won't.
to you the way I want.
No, you won't.
I'm tired of
no,
your
you
nonsense.
won't.
I will.
No, you won't. You're not going to do what
I don't
You're
care
breaking
if I
the
lose
law.
my job, buddy. You're not going to keep
You're gonna
going
lose your
around
job.
and
You're gonna lose.
do
I'll be calling Allied Universal.
Good for you. Good for you.
You will. You'll be back at the hospital.
We have new rules, buddy.
I don't care about your rules.
Well, yeah, I know. You care. All you care about is yourself.
All I care about is the Constitution. That's all I care about.
You and your Constitution. You can stick it.
Yeah.
You're not going anywhere until you fill out a form.
Okay. I could stick the Constitution. Very American, Phil. Hey, get out of my way, man.
You're not going anywhere.
Get out of my way.
I'm telling you, I'll put you through the wall.
Get out of my way. You're not. You will not.
You will not. You're not going anywhere.
You keep pushing me like that. We're gonna have a problem.
Try me, buddy.
We're gonna have a problem.
Try me, buddy.
We're gonna have a problem.
Try me.
Yeah.
I'll knock you down like I knocked trees down all my life.
Yeah.
All this intimidation and threats just for filming in public. Despite the outrageous treatment, Sean stays calm and tries to walk past this power-hungry cop.
You're gonna listen. I got you on camera pushing me.
I'm not pushing you. Just get out of my face.
No. I got you on camera already pushing me. So you can either stop now and stand down, or you're gonna sit in a jail cell tonight. Whichever one you want to do. No, I'm not. I'm about walking in a public building. Excuse me.
Wait here, buddy.
Excuse me. I'm asking you to move. I'm asking you to move.
I'm not gonna move.
I'm gonna keep walking then.
Go ahead, try to walk through me.
I'm not
Try
gonna,
to walk
I'm
through
gonna
me,
keep
buddy.
Walking. I'm gonna keep walking.
Back up, buddy. Back up.
Don't push me. There you go. Look at you. You're gonna go to jail.
You're not going
Now you're gonna go to jail.
Good. That's fine.
Now
That's
you're
fine.
gonna go to jail.
You're not going upstairs
You have
until
no
we get
authority to
forms.
push me.
We
No, get
have
out of
forms
here.
now. You're gonna fill out before you
No,
go.
I'm
Get
not.
out of my face, buddy.
I'm trying to walk. I'm not
You're
trying to
not
look.
going
I'm gonna
anywhere
try and
till
walk
I get
around you.
forms. You're not
So
going-
that way
you're not going
you can't
anywhere.
say that I'm trying
You're not going
to
anywhere.
attack you in any
You're
way.
not going anywhere.
Sean was thrown out of the building once again, and that was the moment he decided to sue the city of Danbury and its police department. The case went to trial, and here the court reviews footage of what happened to the security guard after Sean filed a complaint against him.
See, it is what it is. I'll fill in the blanks. Fill in the best. Reyes circled around me and did not give me his name or accept the department card. As he headed up the stairwell, I thought in the best of City Hall, I keep him around and prevent him from going upstairs. He kept coming toe to toe with me. I extended my arms to prevent him from going to the second floor. Okay.
This is what it is.
If you want to, yeah. All right, do me a favor, we're not done yet. Sit. Where's the pen? You got your pen? Yeah. Okay. Just.
The supervisor realized that Phil had messed up badly and asked him to write a statement about what had happened earlier. Soon after, he tore into the corrupt guard, warning him that he could face serious consequences in court.
I'm gonna submit a warrant. I'm gonna review the camera footage, right?
Yeah.
I'm gonna get his statement. I got his statement, your statement, and the camera footage.
Yeah.
I'm gonna put that all in a report.
Yeah.
I'm gonna review it.
Yeah.
If I have probable cause to believe that your actions
Yeah.
rose to the level of, I would call it an assault, since luckily he admitted to me that he was not injured and
Yeah.
he did not want medical attention.
Yeah.
Although,
I'm injured.
an impairment of, injury,
Yeah.
according to definition, is impairment of physical condition. So I'm not going to do it to you.
Yeah, but I mean, I didn't.
But if
I just like
I know it
hands,
doesn't
that's-
matter. If you push somebody, I'm not going to do it to you because
Yeah.
I don't want to assault you.
Yeah.
But if you impaired
Yeah.
somebody's
Well, it was
physical
nothing like
condition.
that. I just kind of put my hands up.
Well, okay. So, however, if I think it rose to the level of a discon,
Yeah.
I'll submit warrants, maybe even for both of you. If some of his language is to the point where it's
Yeah.
disruptive,
Yeah.
then I'll submit a warrant for both of you, and we'll see and then it's up to
So
the
you told
court.
me I could get arrested?
Yes, it's up to the court. You got physical with somebody that, for the most part, you really had no reason to be physical with.
I didn't want him going. I
Because he
wasn't
was
going
filming.
upstairs.
I know, but for
Yeah.
what? For what? He's filming. What is he doing? Why can't he go upstairs? It's a public building. It's City Hall, for Christ's sake.
Like I said, if I was given those forms,
You know?
Fortunately, all of the evidence was recorded and shown to the judge. Sean's attorney then called a Danbury police sergeant to the stand and grilled him over Sergeant Utter's behavior in the library.
You're involved in this incident. What are you concerned about pertaining to a promotion?
Well, I'll tell you exactly. After I had watched the library incident, I had seen on his channel that nearly every single one of those videos cast the police in a negative light. So I was fearful that regardless of what I did that day, right or wrong, the same would be done to me, as is exactly what happened.
Right. That didn't happen to you, right?
Oh, no, it did.
It did.
Yep.
Okay. And the incident at the library that you're talking about, the videos, you're talking about the videos involving, I think it's Tippett and Utter, and the statement that if he'd done something 20 years ago, he would have been dead and back to some
Objection is what?
20 years ago, fucker would be dead. His teeth would be missing. I don't fucking do it.
I'd have removed his teeth.
The attorney did a remarkable job pressing the sergeant for accountability, but his response was nothing short of bizarre.
Some videos on his YouTube channel, I noticed that all of them casted the police in a negative light. So I was fearful that no matter what I did, I would too be casted in a negative light. And also, what I didn't end up saying was the multitude of threats that were received. I didn't want that. Fortunately for me, I've never received any, but I didn't want that for myself and my family.
Fair enough.
Because there were people who were arrested for making threats against us. No, I'm just saying.
So
that-
let's just move to strike the balance.
He's answering your question.
Okay, fair enough. But you weren't threatened, sir, were you?
At what point?
At any point?
I was. I received a couple on my work voicemail, but I just believe I didn't.
Did you put that in the police report somewhere?
Well, I was threatened after the fact.
Well, threats are important, aren't they?
It depends if you feel threatened or not, and I didn't feel threatened by them, I just deleted them. They were on my work voicemail.
So you didn't feel threatened about what people had said, correct?
Shockingly, the sergeant had no records of any threats. He was bluffing, trying to dodge any accountability. Even worse, the judge's attitude made it obvious he was leaning in favor of the defense, raising serious concerns about the fairness of the trial.
It's a tough thing. I can threaten you right now. It all depends how you feel about it. I would hope that, you wouldn't feel threatened by me, but so at the time, I just deleted those messages. I don't remember if I felt threatened or not, but I didn't want to, I just deleted it. It was only a couple, it wasn't like the other people at all.
And again, in terms of threats, you never received any threats from Mr. Reyes, though, correct?
I never received that?
Yes.
No.
So you're talking about what you viewed outside of the evidence in the courtroom here, in terms of where you're getting the information, correct?
Well, not necessarily, not the threatening parts that I learned from.
Did you have you had the luxury of time to investigate what happened, correct?
Yes.
Okay. And when you investigated it, you submitted a warrant not for Phil,
Correct.
but for Mr. Reyes, correct?
Correct.
But it was Phil Janusa who was the person who was originally complaining, correct?
Phil Janusa was originally complaining about, yes.
All right.
I don't agree with
Did you say that?
Objection relevance.
So that's sustained, that's not relevant. And I think the line of questioning, the warrant, Mr. Reyes, was for the fatality, it wasn't just for the incident in the stairwell, right? You're juxtaposing his conduct in the stairwell with Mr. Janusa's conduct in the stairwell. That's what you're doing?
Well, something like that, but I know that we're here for this particular instance about the trespass and trying to focus on
7/15/21 in total.
Correct.
Okay.
The judge seemed ready to hand the victory to the city of Danbury, but just as Sean's attorney pressed the sergeant harder, the judge interrupted with something completely unnecessary and uncalled for.
Based on that conduct, to have Mr. Reyes arrested, is that what you did?
I would object because that mischaracterized the testimony. He said he had it in the morning, not the afternoon.
Sustained. It does mischaracterize the testimony. Ask a question, Tracy.
Sir,
Yes.
you weren't present in the clerk's office the afternoon of July 15th, 2021, correct?
Objection, asked the answer.
Sustained.
Okay.
We've had that.
Did the warrant that you did for Mr. Reyes pertain to conduct that occurred on July 15th, 2021 in the town clerk's office in the afternoon, sir? Yes or no, if you can?
Statement objection.
No.
Asked the answer.
Okay. We're taking a recess. Counsel in chambers now.
All rise. Court's now in recess.
The sergeant was also under fire for coaching the suspect. But watch how the judge suddenly starts overruling every objection, just as it's the defense's turn to argue.
Mr. Janusa about the authority of his coaching. Is there a reason why you told Mr. Reyes not to return to City Hall?
Objection, Your Honor.
Overruled. Answer the question, Keith.
Because I
To the city of Danbury that you were just asked questions about by the state's attorney. Okay? Didn't you also tell him that it was legal for him to do that, sir?
Yeah, of course it's legal for him to go back. and say-
Those are your exact words.
Yes.
Even if I don't want you to go there, it's within your legal rights to do so. It's legal. That was your words, right?
Yeah.
No further questions, sir.
Who's that?
A few weeks later, the trial ended, and unsurprisingly, the judge ruled in favor of the city of Danbury. Sean was given a trespass notice and ordered to pay a $700 fine. Considering the officer's behavior, it is shocking that this corrupt judge didn't put an end to the injustice. Now, while these tyrants got off easily, this next cop did a crime so heinous he had to be sentenced to life.
I do find that a fixed life sentence is appropriate for the count of murder second degree.
Former Idaho police officer Daniel Howard was arrested and brought to trial for the murder of his wife. For 2 years, Daniel claimed it was suicide, but after a detailed investigation, Daniel was brought in as the prime suspect.
Count 1, is the defendant Daniel C. Howard guilty or not guilty of domestic battery? Guilty. Count 2, is the defendant Daniel C. Howard guilty or not guilty of in the first degree? Not guilty. Is the defendant Daniel Howard guilty or not guilty of second degree murder? Guilty.
Counsel, I'm proposing a sentencing date of May 23rd at 1:30 p.m. That's available. I will order a PSI or a pre-sentence investigation. Mr. Howard, I'll have you talk with your attorney about that. You have the right to participate or not participate in that. You continue to have the right to remain silent. Mr. Howard is remanded into custody. I'll see everyone back May 23rd at 1:30 for sentencing. We will be in recess.
It turns out that Daniel's wife, Kendi, had been planning to leave him for someone else. Consumed by jealousy, this twisted individual strangled his wife, destroying his family in an instant.
I struggle with guilt, and I struggle with not knowing. I wish I could have convinced her to stay with me instead of going home that night. The fear on her face and in her voice when she told me about how she woke up with him standing over her will never leave me. Nothing will fill the hole he has created. Nothing can fix or undo what he has done. But her name can be free. The thought that he can no longer have control over her name, her memory, and her spirit gives me a sense of peace.
As expected, the judge was horrified by the brutality of the crime and ensured this ruthless killer faced the full force of justice.
I'm not that monster, I assure you, that people are portraying me to be.
But what we know, beyond a reasonable doubt, is that you strangled your wife, you murdered her, and then you staged her naked body in the bathtub, shot her through the mouth, and tried to pass us off. That's proven beyond a reasonable doubt. In horrible crimes like this, everybody wants to know why. And often we don't know why. And I can't get inside your brain, but the pretty clear evidence, I agree with the state, is that this was due to, jealousy, greed, pride, anger, revenge, some combination of that.
Before announcing the sentence, the judge didn't hold back. He made sure that Daniel knew exactly what he thought of this remorseless.
When you killed Kendi, your wife, you killed a mother, you killed a grandmother, you killed a sister, you killed a daughter, you killed a coworker, you killed somebody who brought a lot of life and light to those around her and those she touched. And you snuffed that out because of your own pride, greed, and anger. Despite your efforts at the time to appear emotional and sad and distraught, it's clear to me that you're a remorseful killer. And I don't say that lightly. I don't say that lightly at all because we don't like to think that anybody would be like that. The lack of remorse, the lack of caring, and just the callous disregard that you had for Kendi and how her death affected those around her. You were talking about allowing people to live through your own self-control and restraint, understanding why people would quote old ladies and go to prison. And so you're 58 years old. I don't see a lot of rehabilitation, sadly, in your future. Perhaps, but that's not a significant mitigating factor in sentencing you.
Even worse than the murder itself was how this psychopath tried to stage it as a suicide and then hid for 2 years. Finally, justice was about to be served for poor Kendi.
The public needs to know that there is a severe punishment for murdering your wife, and there's no sort of mitigation because the marriage is on the rocks or the wife was unfaithful or things like that. There's absolutely no justification here for murdering your wife, and I think it's important that the sentence sends that message as well. What I know beyond a reasonable doubt is that you strangled or asphyxiated your wife. You murdered her. You staged her body to be found as if it were suicide. It's an outrageously egregious murder. And of course, all murder is, but this is particularly heinous in my view, having sat through the trial and seen all the evidence.
Eventually, the judge handed down the only appropriate sentence in the case of this sick individual.
The offense standing alone is sufficient to justify a fixed life sentence, and that is what I'm going to impose here. I think Kendi's family deserves to have that closure. The crime is so egregious that I don't think...
Howard was in prison for life without any possibility of parole. Now, as tragic as this was, the next case is just as disturbing. A police officer who murdered his own wife and baby.
The detective said, side chick, that's his baby mama. And there's a possibility that the boy is his son. I'm thinking we're supposed to be the good guys. He's supposed to be watching my back.
It is rare to see a police officer held accountable for their crime, but today we bring you some of the most shocking cases of corrupt officers who did the unthinkable and faced justice in court. Starting with a Border Patrol agent who made the most shocking decision of his life. On April 9th, 2018, Laredo police officers and Border Patrol agents were notified about a double homicide that had occurred in a park. The suspect was another Border Patrol agent, Ronald Burgos Avias, who was in his car when the officer stopped him. It wasn't until 2023 that this case was on trial, and the first responders were telling what happened.
The person that was using that car at the time was supposed to meet a Border Patrol agent at the Father Magnoble Park.
Okay.
The transmission that came in was the boyfriend's name was Anthony Burgos.
Okay.
When the radio transmission came up for Anthony Burgos, there was only one Border Patrol agent that was at that location with us. I had just seen him. I had never seen this person before. I see him. He's right near the car, and so I wave him over. I say, "Hey, come here." As he's walking up to us, the name says Burgos. So we look at the name. I'm looking at the name as he's coming over, and I'm just like, "Hey, what?" I think this is the person they just called over the radio, but they said Anthony, and I look at the first name and it's an R.
Ronald Burgos had just committed the ultimate blunder, and he was about to be taken to the cleaners by his fellow Border Patrol agents who wouldn't fall for his bluff.
Tells him, "Hey, what's your name, man?" And he says, "Ronald Burgos." And we're looking for Anthony Burgos. And radio transmissions are coming through, and so it's kind of getting a little hectic. Burgos approaches closer to Reyes. I'm walking next to him. I'm the only uniformed officer. So I'm right next to him, and he says, "Hey man, what's your name?" And then Burgos says, "Ronald Burgos Aviles." He only uses his last names. So then Rick's like, "What's your name, dude? Why are you not telling me your name? What's your name?" And he says, "My name's Ronald Burgos Aviles." And he says, You're not telling me your name. Do you have an ID or something?" And he's like, "No, I don't have an ID."
The Border Patrol agent had just arrived after murdering his ex-girlfriend, the mother of his child Griselda Hernandez, and his 1-year-old baby Dominic Hernandez. It was appalling to see how Burgos reacted after doing something as heinous as this.
Yes, so once I took the belt off, I put it behind his unit, and then I patted him down as the unit approached us. So I patted him down. I located a phone on him and a driver's license in his shirt pocket.
Okay, so, and what did you do with those two items?
I turned over the driver's license to Detective Reyes, and the cell phone, I put it with his property that I had already taken, which was his Sam Brown. I put it in the back of his truck.
The prosecutor moved forward to show the court the dash cam video of the arrest of the Border Patrol agent. As you can see, the corrupt officer had no remorse on his face.
What is it that he's doing in that scene?
He's wiping his arms. Looks like he's cleaning something off or.
What was it that he did right before he wiped his arms?
He licked his finger.
Officer Ronald Burgos was desperately wiping his arms and even sucking his fingers, trying to remove any trace of evidence. He had just used a knife to his ex-girlfriend and their young son, with the evidence plainly visible to everyone.
Come on, man. Oh yeah, he could have just told me straight up, man, instead of making me go through it. Embarrassing, big ordeal.
As the trial progressed, witnesses came forward, and amongst them was a key witness, another Border Patrol agent, Francisco Lara, who made a shocking revelation.
I look south and I see the silhouette of the young woman. So I completely forget about Mr. Burgos and I start running towards the victim.
See the victim?
As soon as I see the victim, I approach and I start yelling, like, "Señora, señora, despierta, estás despierta. Ma'am, wake up." Because at this time, all I see is blood. I told my trainee, I call him Schmitty. I like, "Schmitty, is that what I think I'm looking at?" And I see the silhouette and I immediately start running towards her. And that's when I tell him, like, I start yelling at her, "Estás despierta, are you awake? Do you have any gloves?" He's like, "No, I do not." So I say, "I don't have any gloves." And I asked my trainee, Schmitty, "Do you have any gloves?" And thankfully, being the great agent that he was, he did have a pair of gloves.
Burgos had devised a strategy, as moments after his ex-wife and son, he ended up calling the cops, claiming that a murder had been committed. Officer Lara explains how he tried to con everyone.
And I immediately check for a pulse. I don't feel a pulse. I look at my fingers and they're covered in blood because I checked her neck area. So I don't feel a pulse. So I immediately see her left wrist. It's facing up. I check her wrist and again I do not feel a pulse. Right away I told Mr. Burgos, "Sir, I think she's 10-7, which means that she's dead." And he's like, "Yeah, it looks that way." So I'm radioing everything into our station and I'm letting him know what I'm seeing. At this time, he's standing there. Not really, the supervisor normally takes control of the situation and radios in everything to the station. Once again, he's quiet. I'm the one relaying everything that I'm seeing to the station. I'm processing everything in, I'm taking it in, and I'm telling them what I'm seeing. And right away, I start telling the camera operator to start scanning the river. I tell him, "Scan the river, see if you see anybody going back."
Burgos had used his police training, carry out the crime in a bushy area, where Griselda ended up having 27 stabs, and baby Dominic had received 2 as well.
Next to the victim, I check her. Mr. Burgos is standing over here I guess on the other side of her. So I tell him she's 10-7, which means she's dead. Radio everything in. I told base 2, I think she's dead. They tell me, "Take a step back, trigger the crime scene." So before anything, I told my trainee, "Go to the gate and open it for the paramedics." He takes off. So before I take a step back, I'm surprised to see so much blood. So I grab my head and I'm like, "Where is all this blood coming from?" I take a step back. At the time he picks her up, I could see the shadow of her face.
Officer Lara, a junior at the crime scene, could not believe his eyes as he watched his senior, Officer Burgos, handle the victim with shocking indifference and remained completely unfazed by the brutality of his action.
I get a phone call from my team leader. My team leader tells me, "Hey, we already activated the Border Patrol unions, the lawyers for you. Before you make any statements, we already got lawyers. And I'm like, we already made our official statement. He was surprised. He's like, oh, you did? I'm like, yes. He's like, before he hangs up, he's like, just so you know, there's a rumor saying that the dead woman is Burgos' side chick. I'm like, all right, 10-4, let me call you back.
It wasn't until detectives began investigating the murder that Officer Lara realized that the woman was Burgos' ex-girlfriend and the mother of his child. This revelation left him in a deeply emotional and shocked state.
We just heard her.
Going to question answer basis, Mr.
I'm good, sir. Thank you, Your Honor.
That is exactly how everyone in the court felt, and we can only imagine the condition of Griselda's family. It turned out Burgos had committed this horrible act just because he was refusing to pay child support. Finally, after listening to hours of testimonies and getting evidence, the jury reached a verdict.
In cause number 2018 CRA 852D1, in the case of the state of Texas versus Ronald Anthony Burgos Aviles, the jury has returned a unanimous verdict. I'm about to read the verdict of this jury on punishment as to count number 1. Special issue number 1 on count 1. Whether there is a probability that the defendant, Ronald Anthony Burgos Aviles, would commit criminal acts of violence that would constitute a continuing threat to society. Answer, yes. Signed by the foreperson. Whether taking into consideration all the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant, there is a sufficient mitigating circumstance or circumstances to warrant that a sentence of life imprisonment without parole rather than a death sentence be imposed. Answer, yes. Signed by the foreperson of the jury.
The jury unanimously decided that Burgos would receive life imprisonment instead of the death penalty. Now, many might argue that the death sentence would have been a more fitting punishment for such a heinous crime.
You heard me announce the verdict of the jury with regard to both counts of this indictment. It is now my job to sentence you in accordance with that indictment, with that verdict. Do you understand that?
Yes, sir.
After being found guilty by this jury of 2 counts of capital murder, and after giving us the verdict that they have just announced, it is my job now to pronounce sentence. As to count 1 of capital murder, and as a result of the sentence of the verdict of the jury, you will be sentenced on count 1 as to capital murder to a term of life without the possibility of parole. As to count 2,
Burgos was immediately transferred to the jail and is guaranteed to die there. The shocking encounter truly left everyone speechless, and it is even more saddening that it took 5 years for justice to be delivered to the poor victim's family. Well, nothing might top the brutality shown by this officer, but this next tyrant made another huge mistake.
Nothing in his hands, and he was shot twice
in 2011, during a routine traffic stop, Officer Osvaldo Villarreal fatally shot an unarmed Benny Herrera. The victim's family filed a lawsuit, but it took 5 years for the case to reach pretrial, as Villarreal's attorney attempted to argue for qualified immunity.
It's a tragic case, there's no question about that. But Officer Villarreal was required to make a split-second life and death decision.
What required him to do that? It doesn't look to me as though he was the initiator.
The fact that Mr. Herrera, first of all, he had been acting erratically before the shots were fired, moved from a place of relative safety on the shoulder of the road into the roadway. He was skipping
But if we're
backwards.
talking about Officer Villarreal, how much did he know about the prior behavior?
He saw all of that.
I have to say what you're saying is inconsistent with what I saw on his own camera. That is to say, the point at which he began to get close enough to see anything. Some of that earlier stuff was on the other camera, but not on his.
Officer Villarreal had shot the poor suspect only a second after he asked him to take his hands out of his pocket, and sadly, the attorney was defending this monster.
At what point his camera was turned on, but
His
he
camera,
testified.
his camera was turned on well before he got to the scene.
He testified in deposition that he saw Mr. Herrera on the side of the road, and then he saw.
Well, he can testify to what he wants to testify to, but I want to tell you what I saw on his own camera tells me that the early part of this he did not see, could not see. That was his intention, you say?
That was his intention, and that's in his deposition.
Again, I'm relying on what's on the videotape, and now this is in Officer Villarreal's car. I hear him say, "Take your hand out of your pocket," and I hear the gunshot almost simultaneously.
Exactly.
They cannot be separated by more than a second.
And that's exactly the time period when Officer Villarreal had to make his decision.
Shockingly, even the police department cleared Officer Villarreal's conduct, but the judge had another idea.
Here, Mr. Herrera was arguably complying with Officer Villarreal's order to remove his hand from his pocket at the time that he was shot. So how is it that we determine that we should grant qualified immunity?
Because qualified immunity allows for police officers to make mistakes. It allows for the possibility that officers will make mistakes in judgment, and that's exactly what happened here. Officer Villarreal had a choice to make. Do I wait and see whether there's something in the hand that could kill me, or do I shoot? And he made the decision to fire. We know with the benefit of hindsight, obviously, that was wrong.
Is it safe?
The officer was about to face the consequences of his actions as the judge unanimously decided that his qualified immunity should be tossed.
As long as the historic facts are undisputed, the question of whether or not Officer Villarreal's actions were reasonable is a question of law. It's not a question that you give to a jury, because we don't want juries second-guessing the very, very difficult life and death decisions that officers have to make.
I agree, but at this stage, again, this is not an argument to a jury. For us to even have jurisdiction over this case, we take those facts. You're saying that as a matter of law, the shooting here was legal.
Yes, it was objectively reasonable. Well, not just those facts. Officer Villarreal knew that Mr. Herrera was a suspect in a domestic violence incident. Okay. He knew that he had a gang affiliation, that he was on parole, that he had a warrant out for his arrest. All of those things factor into
on parole. I don't remember on parole. They said
on parole, yes, and there was a warrant out for his arrest.
What do we know about what Officer Villarreal knew with respect to whether he was armed?
We know that dispatch told Officer Villarreal and Officer Miali that Mr. Herrera was not known to be armed.
The attorney continued to make bizarre and illogical arguments, but the judges swiftly rejected them, firmly believing that the officer should at least stand trial for his actions.
No, sir, the suspect had refused to put up his hands, had threatened the officers, and an officer believed that she saw something in the suspect's hand, saw him move his arm, and was worried he was going to shoot her. But yet we affirmed the denial of qualified immunity in part because the suspect had not brandished a weapon or spoken of a weapon.
I do recall that case, Your Honor.
The domestic violence incident was over.
Yes, and there.
So, I mean, how does that strengthen your case? I mean, that was, if you're arguing that it was an ongoing domestic violence, so.
It wasn't an ongoing domestic violence incident, but he was warrant out for his arrest, that he had known gang affiliations, and all of those things factor into, am I afraid of this encounter, or do I think that this is going to be a perfectly safe encounter? And everything that they observed, or a lot of the things that they observed, heightened the situation to a point where it was objectively reasonable for the officers. Nobody disputes that, for example, that it wasn't objectively reasonable for the officers to have their guns out. They were going to do a felony stop. Domestic violence under California law is a felony. So they had their guns out. There's some question about whether or not there were other alternatives available. Well, in the split second that decision had to be made, you couldn't put the gun down and pick up a baton. You couldn't put the gun down and pick up a taser, assuming that Officer Villarreal even had a taser. I think there's testimony in the record that he didn't have a taser available to him. He had to make a decision based solely on what he knew at the time. And it's easy for us to sit in hindsight and say, well, Mr. Herrera didn't have a gun. Mr. Herrera didn't really
Counsel,
pose any
I don't think
threat.
anyone here said that one time.
No,
I think what we're focusing on, again, the narrow standard we have to deal with here, and that's what we're dealing with. This is not a jury trial. This is not summary judgment. It's a very limited thing. No one here has raised about the fact you didn't have a gun.
I understand. The trial court did.
The plaintiff's attorney stepped forward and presented compelling arguments that further solidified the need for the officer to face trial, strengthening the case against him.
And that the officers perceived a heavy object in that pocket. That's...
First part, yes. Second part, a little less clear. But I think there's no question that he had his hand in his pocket.
Well, and both officers said it looked like he had something heavy in his pocket.
Okay.
All right. And then just before Mr. Vial opened fire, Mr. Herrera rapidly removed his hand and moved quickly, it seemed like, toward the officer's car. Why isn't that enough?
Well, because sticking on the undisputed facts, the officers had no information that any weapon was involved in a crime. They were specifically told he was not known to carry weapons. He had nothing in his hands, and he was shot twice and killed. We specifically asked the officers about their training, and they conceded, which is included in the cites in our brief, that deadly force is a last resort, only to be used in the direst of circumstances, only when no other reasonable measures are available. And
finally, the judges reached a conclusion and gave one last shut-up call to the defense attorney.
If everything goes bad for your client, that is to say, if we send it back, if the jury says no qualified immunity, and if the jury comes in with an award of some amount of damages, will your client pay those damages out of his own pocket, or will it be paid by his employer?
It should be 99.9% of the times it's paid by the employer. I don't see why it would be different.
Well, by statute, California statute says it's paid by the employer unless they're punitives.
Yes,
isn't that right?
That was what I was going to say.
So that doesn't say 99%, it says 100.
Well, I was going to say, unless they're
punitives.
If there were punitive damages, the city would have the option of deciding whether to pay those punitives.
Next, watch how this dangerous police officer took the law into his own hands and faced the consequences in court.
That was before the
Don't get brazen with me.
Courtrooms often mark the downfall of corrupt officers who believe they can act without accountability. Today, we'll explore cases where these officers were exposed and humbled in court. Stick around till the end. The last cop's actions will leave you speechless. Our first case is about the evil cop, Michael Amiot, who punched and kicked a person after pulling him over for a traffic stop. It didn't take long for the jury to reach its verdict.
We, the jury, being duly impaneled and sworn, do hereby find the defendant Michael Amiot guilty of assault, a misdemeanor of the first degree, in violation of section 2903.13A of the Ohio Revised Code as charged in count 2. We do so render our verdict this 29th day of July. Do hereby find the defendant Michael Amiot guilty of interfering with civil rights, a misdemeanor of the first degree, in violation of section 2921.45A of the Ohio Revised Code as charged in count 3. We do so render our verdict this 29th day of July, 2022.
The corrupt cop was found guilty on both counts. He sat there in silence, keeping a straight face, and clearly showed no remorse for his actions.
That is your decision as to whether you wish to speak with them. With that, anything prior to discharging the jury?
No, Your Honor.
On behalf of the defendant, anything? Yes. Well,
that wasn't the end of the trial, as the very next day, Amiot was called to sentencing. The victim was present and allowed to share a statement before the sentence was handed down.
I appreciate the jury and the court for making the right decision. You know, what Amiot did, something was wrong. He should have received the maximum sentences today. You know, I'm still going through like the suffering with the anxiety, you know, driving, just the temperament, the trauma and everything. This is a cause for this case. I'm ready to get it over it actually, but just coming back in here just like bring up everything. You know, and just to see him over there, you know, see all that just coming back in this court, just like it just brings up everything. Like, we live at the moment. So, you know, I hope he gets the maximum sentences with that.
Shortly after, Amiot was allowed to address the court, and he delivered a lengthy statement.
One of the most shocking examples was a prosecution witness called who testified that I was celebrating in the aftermath of this arrest. They testified that I was high-fiving, fist-bumping, and dapping it up with other officers. There was 5 police cars on East 228th Street that day, all with their dash cameras on and rolling. They all had overlapping fields of view. I can be seen in front of one of those cameras the entire time I was on scene until I was transported to the hospital. Nothing remotely close to what the witness described happened with me or any other officer on the scene. They knew this and put the witness on the stand anyway.
The officer continued to offer explanations in an attempt to clear his conscience. Eventually, he took some accountability, but only to a minimal extent.
I take full responsibility that there was a failure on my behalf to get Mr. Hubbard in custody quickly. The incident was prolonged when I was shot with a taser. During the deployment, I broke my hand, ruptured tendons, and injured my shoulder. I want to end by saying I'm not an advocate for or against use of force. Everything I did on that day was based on my training and experience. From here on out, I'll be an advocate for subject control training department-wide going forward so we can all be at our best when the time comes. I have a deep respect and love for the citizens and this community. I want to do my best to serve them.
Before announcing the sentence, the judge expressed his disdain for Amiot's actions, aiming to make the officer feel the weight of his wrongdoing.
One of the things that stood out to me is that the initiation of this incident probably never should have occurred. When you receive that initial radio communication, that initiated this whole thing. And the other thing that sort of stood out to me was that in approaching the vehicle and asking Mr. Hubbard to get out of the vehicle, there was an inability for him to get out of that vehicle without making contact with you.
It is disheartening that Amiot never apologized to the victim, and the judge's personal comments must have been especially hard for him to hear.
I believe the jury got it right. I do. And the court must impose the sentence that the court feels is appropriate in a case like this. And I appreciate the city of Euclid compensated you. If you need assistance, you need to go and get that assistance. But I'm not going to say you're not going to have instances of flashback or what have you, but you need to move on with your life also. And not let this incident continue to hover over you. The city compensated you.
The judge also tried to tell the victim to get back to life and move on from this terrible incident. Finally, the sentence was announced for the tyrant cop.
The court at this time will impose a sentence of 90 days, require you to pay a fine of $1,000, and will require you to pay the court costs. In addition, the court will suspend the sentence of 90 days, place you on non-reporting community control for a period of 1 year. If you violate during that 1 year, then the court will retain the ability to impose the sentence. Anything on behalf of the state?
No, Your Honor.
On behalf of Ms. Amiot?
Just what count is this in? Court electing the sentence?
What count as opposed to the violation of civil rights? Not saying they weren't violated, but given the length of time, the court will use the assault charge. Anything else?
Judge Guy Reese sentenced Amiot to 90 days in prison and also fired him from the police force to ensure that such barbaric behavior would never happen again. While this judge was quite relaxed, this next one took this attorney to the cleaners.
And the court left the door open.
For me, not for you.
That was before the defense
Don't
testimony.
get brazen with me.
During the Kyle Rittenhouse homicide case, Assistant District Attorney Thomas Binger ignored the judge's previous rulings and continued questioning the banned topic. This led to a furious defense attorney and an even angrier judge.
I'm going to ask you to go into the library again for a moment, please. Please don't talk about the case.
He's either forgetting the court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's asking the questions. I asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice. He's an
First of all, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door open.
For me, not for you.
It was clear that Judge Schroeder was extremely angry at the prosecutor as he dismissed the jury for a while to hold him accountable.
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not our
Excuse me,
motion.
Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that. So I don't know what you're up to.
The prosecutor had made a huge mistake, and things were about to get from bad to worse for the poor guy.
He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect...
I'm not going to rehash the motion. That's absolutely untrue. No. Your argument's of record. My comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed, even if you're correct in your assumption that you know more than I did at the time. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
The defense panel was growing restless, unable to believe what they were hearing. Binger's excuses were weak, and he was about to be called out for them.
The defendant has just testified this morning that he agreed with that person in the yellow pants, that he pointed the gun at him. He said, I was joking when I said that to the guy in the yellow pants, but he's acknowledged that he told the person in the yellow pants, yeah, you're right. I did point a gun at you when you were sitting on a car.
He said, I did. That's what he
Exactly.
testified. You know, there's a lot of difference between commenting about something when you haven't got a gun and threatening someone when you do.
You know, it's interesting, Your Honor, because the entire defense theory in this case is Joseph Rosenbaum, who was unarmed.
I want you to tell me what the defense theory of the case is. May I
respond to what you just said, Your Honor? I'd like to respond to what you just said. I apologize, Madam Court Reporter, but I'd like to try and make a record without...
It's rare to see attorneys speak to police officers in this manner, and if Binger continues this behavior, he could be held in contempt of court.
On his beliefs and on his statements.
I'm going to interrupt you now because you're talking about his beliefs. I think that's what they call...
His statements too, Your Honor. Because he just said, can't use deadly force, can't threaten to use deadly force to protect property. So now I'm impeaching him on that.
Your Honor, the court has seen no reason to change its ruling And just so this record is clear, in spite of the lengthy statement by Mr. Binger, before we started today, the court specifically stated in Mr. Binger's presence, there's been nothing to have me change any of my rulings. He knows if you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission. This is ridiculous.
It wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence.
The judge taught him a lesson about who the boss was, and just when he tried to talk over him, he delivered one final blow.
His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense
Don't
testimony.
get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Wigmore and evidence. Judge Weinstein. Colonel McCormick. It's the prior act has to bear the signature of the accused, or it has to be so similar as to suggest it's a common plan or something like that.
The judge delivered a brief speech to instill discipline in his courtroom before calling the jury back.
When you were I said you were over the line and close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Thank you. Ask the jury to come back in, please.
This was surely humiliating for the attorney, and he'll forever think that he should never have broken the rules. Coming back to police officers, here is another instance when a corrupt bully was questioned and owned.
Did you apprehend good guys?
Did.
Never.
I take that back. I bit a victim one time because she jumped in front of me.
Daytona Beach police officer Joshua Mezero was involved in a gun battle with Marvin Jones, who was shot 5 times. Jones also had his girlfriend with him, Aviana Bailey, who the officer also shot. The young mother-to-be was left paralyzed from the chest down after the incident. Following this life-altering event, she filed a lawsuit against the police and the city.
Playing, fumbling, doing something in his lap. There's none of this, there's none of this, it's this. And he's looking at me the whole time. And then it happens.
What happened?
He sticks the gun out the window and points it at me.
Okay, how does he stick the gun out the window?
If I'm sitting in the driver's seat, where would my... So he just went just like that.
Okay.
And it was between the mirror and the A-post.
Okay.
Well, actually, if I'm driving...
Exactly.
I'm sorry. If I'm driving, the driver's side the door is here. So he did this.
Okay. Because you had him moving.
Excuse me.
Further into the passenger compartment.
No, that was completely.
Right.
That was my mix-up in the side. It was the right side that he did it with, and then he put the gun between the window.
Officer Joshua couldn't even get the story straight, and you'll be shocked to see how casually he took the deposition.
You said right side again.
Left side. I'm dyslexic.
Are you dyslexic?
No,
okay.
I'm sorry. I didn't. That was a bad joke.
Do you recall how many rounds?
Just one at that time.
Okay. And where did it strike?
The hood and windshield area, right in front of him.
And how many muzzle flashes did you see in total at scene 2?
At least the initial, at least 1, and possibly 2. I can't count them. I can't tell you how many exactly I saw.
The officer's demeanor clearly showed his ego, as he was taking everything just a little too lightly. It was clear he had no understanding how drastically Bailey's life had been altered. She could no longer even care for her baby.
I was committed to engaging him, and I did that, at which point my ankle rolled off the curb and I fell on my back.
Okay.
I was falling and still shooting, so somehow the gun jammed from limp wristing it.
Okay. That were fired at you, or you saw several muzzle flashes?
Yes.
How do you define several?
Objective form.
One or two? Two, probably.
Okay. Several's not one.
Yeah.
What we agree to that? Do you mean is several more than two?
Objective form.
I would say two. So we'll say a couple.
Okay.
Investigators pressed Joshua about the tragic incident, but he continued to make light of this serious situation, attempting to joke instead of addressing it responsibly.
In your deposition, you discussed dust. Tell me about that.
Form.
Was there dust at scene 2?
Yes.
Tell me about that.
Form.
There was dust at scene 2.
And I understand there may have been dust on the ground, but did the dust become airborne?
Yes, from the suspect's vehicle spinning in the grass, which was dry.
Did the dust settle? What do we say? Before you got out of your car?
No.
Okay, so there was still some dust in the air.
Correct.
When did the dust settle?
Still hasn't settled. I guess it never really did. I mean, that I remember.
Okay. Now, before you got out of your car and engaged Marvin Jones, did you know anything about him or his background?
Just the fact that he might have some felony warrants out of New Hampshire.
How did you learn that?
Apparently, somebody called from New Hampshire to rat him out.
Joshua had no remorse for his action, and as the deposition continued, his answers were about to get even more weird.
What threat was posed to the safety of an officer or other person at the point you first got out of your car?
There was none.
Okay. What threat to an officer or other was posed when you first drew your firearm?
There was none.
What threat to an officer or other was posed when you got out of your car, when you took a step towards the Lincoln?
Objective form.
At this point, the defendant's actions.
Okay. Which were what?
Fumbling around on his, making very furtive movements.
Okay.
Kept looking at me.
The attorney then questioned Joshua about his troubled past, which included being removed from his role as a canine officer. When pressed on this matter, his cocky and dismissive responses were shocking.
Did you have your duties as a canine handler revoked or rescinded at any point?
Yes, I did.
What happened or why?
Form of objection.
In my opinion,
Yes.
I was doing my job too well.
What does that mean?
It means I was beating the streets and I was catching bad guys.
Okay.
There wasn't a lot of bad guys that got away from me
Because your dog got him?
because we got them as a team.
Okay.
And if you have an above average bite ratio, that means you could be using your dog too much.
Okay.
A bite ratio is how many people you apprehend and then how many people you dog bite during that apprehension. So they're saying 30%. So they're saying out of 10 people that you apprehend, you should bite 3 of them, let's say.
Okay.
Which never made any sense to me.
The officer was so arrogant that he had no clue that he was appearing stupid. His desperate attempt to portray himself in a positive light only highlighted his dangerous and bullying nature.
When was your canine handler duties taken away?
Late 2011. As a matter of fact, December 23rd, 2011.
Okay. Why is that date stick out?
Worst day of my life. I enjoyed the job. I would have paid the city to come do that job. Tracking down bad guys and finding them and apprehending them.
Did you apprehend good guys?
Never. I take that back. I bit a victim one time because she jumped in front of me. So
I did. I bet a victim one time.
Was that another officer?
No, it was a victim, a domestic violence victim.
Joshua's history was riddled with poor decisions and excessive use of force. The attorney dug deeper, exposing his psychopathic nature.
Do you need supervisor authority to conduct a strip search?
Yes, sir.
Did you obtain supervisor authority before you searched Justin Riddle?
No, sir.
Did you receive counseling or did a supervisor talk to you about that and tell you did that portion incorrectly?
Yes, sir.
Okay. March 2011, there was a newspaper article about a lawyer that claimed you used excessive force. Do you recall that incident?
Yes, sir.
Tell me about that.
He was, Roe. He was hammered. He was drunk.
Oh yeah, I remember this one. This is the one where you were alleged to have gone in a home without permission, like moved somebody's arm. You recall that incident? What happened there?
I was on K9. We were looking for, they're twins. There's two of them. I forget their names, but we saw one on the bed through the window. And I'm like, that's him. That's him. But this is before I knew he had a twin or a brother. So he had a felony warrant.
The twin did?
No.
The one of them.
The one of them had a felony warrant.
The guilty one, not the innocent one.
So the mother's there, and we got the place surrounded, and basically she said, you're not coming in. Well, he's in there. We can see him in there. We can force entry on a felony warrant if we see the person and we confirm it's him. I eat that one. That was my responsibility all day long for not knowing that it's the brother. They do look different. If I had seen his face, maybe pay attention to his haircut.
Did you ever arrest a good guy?
Did I ever arrest a good guy?
Yeah.
Not that I can recall.
So.
Eventually, the tyrant cop was saved by qualified immunity. But poor Bailey did receive some settlement money from the city. Now that won't be solving her problems, but it might give her something to cheer about. And that brings us to the end of this video. Today we witnessed corrupt cops being held accountable in court and some shocking courtroom moments. It is astounding how these officers act as if they are above the law, causing irreparable harm to innocent lives. However, these cases serve as a wake-up call for others in law enforcement to reflect, reform, and uphold their duty with integrity. If you agree with me, please support us by liking this video. Also, if you enjoyed this video, watch some more of these satisfying moments when officers were humbled in courtrooms.
Then I want you taking him up on perjury.
Your Honor.
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn
Absolutely
citation.
not, Your Honor.